Hello everyone, my name is Daniel Kriegers. I'm an employment lawyer with Chadwick Lawrence Solicitors. This week's update is a simple introduction to restrictive covenants or post-termination restrictions within employment contracts. And typically these have always been reserved for senior employees, but increasingly we are now starting to see them included in more junior drafts, particularly where the role exposes somebody to confidential, technical or strategic business information. I'm just going to take you through a number of different types of covenant that can be included in the contract and some important notes to consider when drafting for the first time. So perhaps the most restrictive covenant that there is, which can be imposed on an employee, is that of non-competition. So that may be working in a competing business or a prohibition on setting up and operating a competing activity. These tend to be the hardest to be enforced by the courts, and typically the view is that these will fail where there is adequate protection afforded by a less onerous restriction. Non-poaching covenants, they prevent ex-employees from enticing existing staff to resign and join that ex-employee or their business. Non-dealing covenants are perhaps the most common, along with non-solicitation. These prevent an ex-employee from entering into dealings or transactions with clients, irrespective of whether solicitation has taken place. That tends to be limited to only those customers with whom your employee had a relationship with. And as I say, they tend to go hand in hand with non-solicitation restrictions. So these prevent an employee from actively approaching, enticing away or facilitating the solicitation of clients, customers and suppliers. So this goes beyond dealings and does require some active conduct on the part of the employee to try and take that business relationship away. Covenants have to be drafted extremely carefully in order for them to be enforceable. Blanket restrictions which are too wide are likely to fail, and if an employer cannot justify why the restriction is in place, it is likely to be struck down by a court. The clauses have to be drafted specifically to protect the business's legitimate interests and go no further than is absolutely necessary in order to do so. Covenants can be drafted to apply to a specific geographical region. They can be limited to performing the same or similar role, limited to a specific sector, such as digital marketing, for example, or with a focus on the specific interest to be protected, such as trade secrets. And the process of narrowing down those restrictions in these ways may increase the likelihood of their enforceability if they can be justified, as we've said, for a legitimate purpose of protecting business interests, as opposed to a blanket ban for all employees. And now, if the restrictive covenant is found to be too onerous, goes too far to protect the legitimate interests, a court can, with their discretion, substitute a more appropriate period restriction or type, or alternatively, a very literal approach would be to simply strike down the entire clause. Now, one consideration is the length of the enforcement period, which is considered by the court. For senior management staff, some restrictions may be lengthened to 12 months. For more junior members of staff, we tend to see 6-month restrictions applying for these to be more suitable. And often that comes with an additional clause that states that any period served on garden leave will be taken into account for the purposes of calculating that 6-month period. So what happens if we become aware that an employee is breaching their restrictive covenants after termination of employment? Typically, a letter can be drafted initially reminding the employee of the importance of those restrictions, and if there is evidence of any breach, perhaps requiring undertakings for the employee to sign and return. This is effectively a legal promise to confirm that they will not commit any further breaches of contract, and possibly as well promise to return, delete, irretrievably destroy any confidential information which has been provided. The benefit to the employer in those circumstances of drafting pre-claim correspondence is that it can be a more cost-effective way of resolving the matter. If we get undertakings as well, they can be used in any future proceedings if the employee does continue to breach. The downside is that it isn't as strong as court action. It's a pre-action step, and it really does depend on the strength and tone of that letter as to whether the employee is persuaded to act in a different way. Now, if the employee ignores that correspondence or fails to provide the undertakings, continues to breach, typically the next action that the employer would take is to issue proceedings. Now, that could be an application for an injunction, so an application to request the court to enforce those provisions, and often as well that's in conjunction with an action for damages. So if the company can identify that loss has been sustained as a result of the breach, then those losses will be claimed as part of the action as well. So typically, particularly with non-solicitation clauses, if a significant client is lost, your ex-employee had dealings with those and still within the restricted period, an assessment can be undertaken of how much money has been lost. So if you require any advice on drafting restrictive covenants, enforcing the same, or have any employment law queries generally, please do get in touch by emailing employmenthub@chadlaw.co.uk or visiting our website for more resources, www.chadwicklawrence.co.uk. Thank you.